To summarise it, it's the track we're talking about is land that we don't consider to be part of the garden ground associated with the adjacent house, although it is in the ownership of the owner of the house. And therefore it's not ground that's excluded from access rights on the ground of reasonable privacy, and therefore access rights apply. The council has a duty to uphold access rights under the legislation, and we therefore consider it appropriate that the council takes further steps towards having the obstructions that are currently there removed. So we're therefore recommending that the committee should agree to this council serving a notice requiring removal of obstructions, and in the event of that being appealed, that council would defend any subsequent court case. As I say, the details in the report, not sure there's any point in me repeating that, but I'm happy to answer any questions relating to that.
Yeah, we'll get that further down. So is that all you wish to say, Mr. Clark? Yeah.
Yes.
At the moment, that's great. Thank you. So I think the next process then is to move on to ask Mr. Millen to speak on behalf of his client. So over to you, Scott.
Thank you, Convener Salmond. Members of the committee should have before them a copy of a response prepared by a colleague of mine to Mr. Clark's report. It sets out in a reasonable degree of detail why, in Mr. McIntosh's opinion, this order should not be made, and why it is reasonable for the public to be excluded from using this as a through route from Ferry Road to some fields behind his property. Just by way of background, Mr. and Mrs. McIntosh acquired this property in 2020. As Mr. Clark has very fairly pointed out, there are two principal bases upon which the McIntoshes oppose the continued use of this track by the public, and one is to protect the privacy and enjoyment of their property, and the second is safety. Mr. Clark acknowledged that the McIntoshes have title to the track in question, and whilst I describe it as a track, it is truly both a track and an access to their home. Their home is accessed from Ferry Road in Monifieth, I believe Protty Ferry, which members will be aware is a busy road. The privacy and enjoyment part of their submission is that a great many people, or a significant number of people, have in the past used this route, and that has resulted in a disruption to their privacy because it is remarkably close to the living part of the property. I think there are plans before the committee may be able to form their own view on that. The McIntoshes completely recognise that this route may well have been used in the past, but they also have the view that they have experienced, until the route was blocked up, considerable disruption to their privacy and damage to their property. Not physical damage, but dog fouling principally has been the main problem, and people congregating in their drive. The previous proprietor used the property in this way. He used to park an HGV because he was an HGV driver on the track over weekends when he wasn't working, and during the week he would park his private vehicle in the track. However, despite the disruption to their enjoyment of their own property, the principal concern, I think, revolves around safety. As members will be aware, the track or drive accesses directly from Ferry Road, and it's not possible until the driver of a vehicle is actually facing down the track from Ferry Road to tell whether or not there's somebody in the way. Therefore, pedestrians are at significant risk to their own safety by being allowed to continue using the track. It would be my submission on behalf of the Macintoshes that an assessment of this should be undertaken by some of the transport team within the council. The members of the committee will be familiar, way more familiar than I, with assessments which are made normally in the context of planning applications about the aspect of accesses from busy public roads, which in this case is made worse by people parking on the south side of the road. So you've effectively got a very narrow, not a very narrow, but a narrower track or a narrower route from which people are turning left to get into this road. That causes them sometimes to cut the corner and has on occasion caused damage to both vehicles and property belonging to the Macintoshes. However, it is public safety which is the primary source of concern to the Macintoshes, and in my submission it would be helpful to get some input from some of the transport department at the council as to the viewing, I don't know quite what the expressions are, viewing aspects from both coming out of the drive onto the public road, but more seriously, I think, to try and maintain the flow of traffic, people coming off the main road, turning into the drive, and the danger that might present to those who are already using the drive to get access to the field to the back. I should just say that to begin with, there was a great deal of abuse directed at the Macintoshes from the local community on social media. However, over the last year or so, that has died down completely, and there is no current vitriol being directed toward them. I would also remind the committee that there is an alternative access to the fields behind the Macintoshes' home, and that is via Weems Crescent. So taking everything into account, taking the fact that the Macintoshes do own this strip of ground, it forms an integral part of the enjoyment of their property. Combining that with the safety element means there is a significant risk that if this obstacle is removed and members of the public are again allowed to use their will this track, then there is serious risk to public health and injury to users of that track. I'm happy to answer any questions which members may have, but these are the principal submissions that I have today.
Okay, thank you, Mr. Millen. So the next section, let me just read this. So, Karen, do you want to keep me right? This next section, is this for Mr. Scott, Paul, and the members to ask questions in that order? So it's not answer it. So that we're asking questions rather than having questions answered by us. That makes sense. So if I'm reading this, so that's the correct process. So I think if Mr. Millen has any questions, I assume to Mr. Clark or to any of our other council representatives, this is the opportunity. So, for example, Scott, I think one of your questions you had, it would have been about the what I would call sight lines for our traffic team on this. So if I can maybe ask Mr. Thompson for some guidance here. Is that something that we can, I presume we can't provide it at the moment, is that something we can provide, or is that something that we should provide?
Thank you, convener. I would appreciate Mr. Milne and Mr. Clark's views on this, but my reading of the Act is that the land in respect of which access rights are not exercisable doesn't include issues in relation to safety. But I would also highlight, and bear with me till I find out the relevant section of the Act, is that Section 15 of the Act provides that a local authority may take such steps which may include the putting up and maintenance of notices and fences as appear to them appropriate to warn the public of and protect the public from danger on any land in respect of which access rights are exercisable, or to indicate or enclose or to give directions to any such land. So subject to any comments that Mr. Clark and Mr. Milne might have, my view would be that strictly in terms of the Act, road safety and access considerations are not relevant to whether or not access rights are exercisable.
Okay. We'll go back to Mr. Millen because we're going to do this in a process. So I think Mr. Millen's first. So please, Scott.
Thank you, Mr. Simon, convener. My understanding is that relates to inherent dangers once you're actually on the ground. It doesn't, such as wild animals. I read some of the case law. There was signs up about wild boar in a site near Stirling. I find it hard to believe that the law excludes considerations such as danger from vehicular traffic. That would be extraordinary if that were the intention of the legislature when that piece of legislation was enacted. I think that that would be a legitimate concern which members of the committee could take into account.
Okay, thank you. Mr. Clark, did you want to address that point?
I think David's pretty much covered it. In terms of signage, my understanding is it can deal with not just things like wild animals, but physical hazards and so on. And yeah, potentially signage could be used to help make public aware of the need to take care and so on if you're using the track. But I think the management of how people use the track is a separate issue as to whether access rights apply in the first place, which is principally what the issue is at stake here.
Okay, right, Scott, back to you.
Thank you. I should remind members, in case they're not already aware, from their own report, this track is only the width of one vehicle. It's not. We're not talking about an area of several tens or hundreds of acres. We're talking about a very, very narrow track, which is one vehicle width. Therefore, it's going to be very, very difficult to. You can make people more aware of the danger by putting up a sign, but with respect, that isn't going to prevent accidents if someone comes in, turning off Ferry Road and collides with either a member of the public using the track, a child or a dog.
Okay, so we're at questions and we're still with you, Scott. Have you got anything else that you'd like to ask?
I think Mr. Clark, I'm not quite sure the detail of this, but I think Mr. Clark had an observation to make in relation to a previous planning application in relation to the subjects, when he himself expressed some concern about danger to members of the public, members of the public using the track in connection with a previous planning application made by the McPhersons. So the Macintoshes, sorry.
Mr. Clark, can you recall?
I'm afraid I can't recall the precise wording of any comments I made to previous planning application. I know from recollection, my view was that approval of the current layout, which is a track, which is a parking area accessed from the track. I didn't have any significant concerns about that, provided the parking area was separate from the track. I would have to check the wording to comment any further, which I don't have in front of me, unfortunately.
Sorry, Scott, 2 seconds. Mr. Thompson, can I just get some guidance? Is that relevant to this decision today?
In terms of perhaps maybe it'd be relevant to. I see Mr. Milne's got his hand up, convener. Maybe if we could hear from him before I offer advice.
Right, we'll go back to Mr. Milne then, please.
Thank you, Mr. Convener. I'm just looking through my notes here. I don't actually have the email from Mr. Clark, but it is said that Mr. Clark had issues with the first planning application made by the Macintoshes, as he thought that cars accessing the front of the house may be a danger to the public. Given that statement has been allegedly made by Mr. Clark, I'm not quite sure how he can deny that there must still be some danger to the public from members of the public using the track from others accessing the private property in a vehicle.
Okay, David, back to you.
Thanks, convener. All I can do is refer the members to Section 6 of the Land Reform Scotland Act, and that sets out the description of land over which access rights are not exercisable. And I fully take on board the issues that Mr. Milne has raised about safety. However, the safety is not referenced in this section. And I would again mention that, but also mention the measures that a local authority can take to in terms of. Sorry, I'm just going back to the relevant section. That Section 15 permits a local authority to take measures for the safety, protection, and guidance and assistance of the public. And as I say, I don't think I've got anything more to add on that.
Okay, thank you. So we'll go back to Scott to see if he's got any more questions. He does. On you go.
Thank you. Sorry. Just one final thing. If the concern, if there is a potential concern, and it's hard to see that there wouldn't be one occurring to the members, then that to me, and referring to the section that Mr. Thompson just referred to, it seems odd that the council would not seek the input of the transport team in relation to sight lines, because the council needs that sort of information before it can consider what, if any, warnings ought to be erected for protection of the public. You can't really do that, I don't think, without some input from the transport experts.
Okay, thank you. Mr. Thompson or Mr. Clark, do you want to respond to that? No.
Yeah, no.
There you go, David. Thank you.
Thank you, convener. I mean, I think the issue that Mr. Milne has raised. I think Mr. Clark earlier on alluded to the existence of the access right is a separate issue from the management of the access right, and that the measures that the council could take is obviously something that Mr. Clark's alive to. And I think there's two issues here, which one is it an access right, and can it be properly managed? One issue I would mention that it is open to the owner of land to actually apply to the court to get a declarative from the court that the land is not subject to access rights, and that's contained in, I think it's Section 28. So it is open to a landowner to actually apply to the court to actually to have the court declare that access rights don't apply to an area of land in question. And that's section 28, convener.
Okay, thank you. Right, we'll go back to Mr. Milne. Have you got any further questions, or was that your last?
I'm finished. Thank you very much.
Thank you very much. Thank you. Right, so I think we move to Paul. Clark, have you got any questions?
No, no questions from me. Thank you.
That's great. So we now move to the elected members. So do any elected members have questions? Councillor Hans, please.
Thanks, convener. I just want to make a wee bit of a statement, first of all, in terms of the issue with the communication between, from Paul Clark, in terms of the email. If that was going to be raised, it would have been quite helpful to have had a copy of that in the papers for today's subcommittee. But Mr. Milne, given that you've mentioned safety and there's a bit of uncertainty as to whether we should be looking at that at all, but given that you have discussed it, this track has been used by people in Moneyfield for quite a long time. So if you're concerned with safety, did you also do an investigation into any previous accidents in the area in terms of asking the council or asking local police to see if they had been aware of any incidents?
Mr. Millen, please.
Thank you, convener. The answer is no, we haven't done that. As you know, the current proprietors, our clients, have only owned the property for the last 2 years or so. I think I mentioned in the latter stages of my submission that there's been damage to vehicles and damage to property on the way into the entrance of the track, but I'm not aware of anyone having been injured during our client's period of ownership. But you must remember that it has been effectively closed to the public since, I think, 2020, probably about 18 months or so, I think.
Sorry, can I just intervene for a second? I've just had a text from somebody. Can we just check that the live stream's actually working? I've had a text to say it's not.
There is an issue with it's an issue with the live stream. It's being recorded by Sandra at the moment. It'll be uploaded afterwards, but it wouldn't connect to YouTube for some reason this morning. No idea why, but it is being recorded and will be uploaded later.
Brilliant. Okay, thank you. So we're okay. That's all okay. Sorry, Sheila, I'll just be 2 seconds. Is that we're all okay with that then legally if we're recording it and we upload it later on?
That's what we did initially, so I'm assuming it's okay.
Thank you. That's great. Sorry, Sheila, back to you.
Yeah, no, I have a second question, and again, it relates to the safety issue. I just wonder whether, if safety was such a concern, are you aware that the former head teacher of Moneyfield High School was so concerned about the path being closed to pupils that she came and made representation to the community council in order for the community council to take this on as an issue for having access opened up? So I'm just, if a head teacher thinks it's safe for her pupils, I'm just a wee bit uncertain why we're so concerned now with safety.
Mr. Millen, would you like to address that point?
I honestly don't know. I wasn't aware that the head teacher had expressed such a view, or indeed any view, but I would have thought it's a matter of common sense for the members of the committee today that anyone turning in from a busy road such as Ferry Road into a narrow access is bound to present an element of danger if there's people in that driveway. I don't know whether I don't know on what basis the head teacher had expressed that view, or indeed what view she expressed. So I don't think that that's a matter of any materiality for the committee. The committee are here to make up their own mind based on the representations here today, the papers before them.
Okay, thank you. Councillor Hans, do you have any further questions?
So that's me. Thank you very much, convener.
Thank you very much. Councillor Whiteside, you're next, please.
Thank you, convener. Thanks for speaking to us, Mr. Milne. I have a couple of questions. When the property was purchased, there was obviously public access in place, and the track was actually completely separated from the property with a wall the full length. Do you feel that there was adequate due diligence done when they were making the purchase, if they had planned to block public access at that time. The other point I would like to make, in terms of safety and also issues such as dog fouling, unfortunately, these are not unique to this property. There's many, I think properties all along that road will suffer the same problem with safety when they're driving into a driveway, and I think, you know, it's everybody's duty to be careful, and you wouldn't be driving into a driveway like that at any speed at all. So I don't think that argument is adequate to make us remove the right of access to the public. But I'd be interested in your views. Thanks.
Okay, Mr. Millen, please.
Thank you. First of all, I think that there is a wall, a high wall to the rear of the property, but there's no wall to the front of the property. So that's just sort of a point of information. I think the wall only extends probably for the latter half, the north half of the drive, and the whole of the front of the property is exposed to visibility from members of the public using the track. I accept that dog fouling is unfortunately a common problem. However, the problem here was made worse by members of the public throwing, I think what are known as poo bags, effectively into the Macintosh's garden, both front and back, after the wall was erected at the rear. It was frequently the case that mess was thrown over the wall, and that happened to a lesser extent to the front of the property as well.
Can I just come back and
What you said, yeah.
The comment about the wall was in place when the property was purchased, all the way to the front of the property, I believe. We've seen photographs of that.
I think it was just a dwarf wall. It wasn't a full height wall. There's a full height wall to the rear, but only a dwarf wall for the front section. Yeah,
but that wall was in place, and that separated the track all the way. There wasn't an opening in it when the property was purchased, and it was clearly a path that was used by the public at that point in time.
Mr. Millen.
I don't know the detail on that point, I'm afraid. But my understanding is that the property has been used on an occasional basis prior to our client's purchase of it as a means of access to the field to the rear. No doubt, often by dogs, because dogs can run about back there quite safely, which is ideal. But they can also access it via Weems Crescent. There's no necessity for them to access it via the private property owned by the Macintoshes.
I think the papers point out there's quite significant barriers to access from some other routes for some members of the population.
Want to come back to that, Mr. Millen?
I don't quite know what they would be, because the access from Weems Crescent is used by the council in order to manage the ground that sits behind the Macintosh's house. So there must be a reasonable access. I think that the report also points out that the track up the drive belonging to the Macintoshes is not suitable for wheelchairs and not suitable for prams. So it's fairly rough and ready. It's not in great shape, unlike the access via Weems, which is a prepared access.
Okay, Councillor Whiteside, do you have any further questions?
Not at the moment, thanks, Convener.
No, I think this is our only opportunity for questions. But I'll just go and ask Councillor Laurie as the other Money Fieth member. Do you have any questions, Councillor Laurie?
I think anything I had in mind's pretty much been covered by Councillor Whiteside and Hans, so I'm just listening carefully. Thanks, Convener. Okay,
thank you. And then I'll just go to the Vice Convener. Councillor Stewart, have you got any questions?
No, everything has been covered by Councillor White and Hans. Thank you.
Very much. So I think that ends the section. I'll just give anybody another opportunity before I close it, because this is the section for questions. So Is there any other questions before we move to the next segment? No. Okay, so the next segment then is for Mr. Millen to sum up. So if I could ask Mr. Millen to sum up then, please.
Thank you, Convener. I don't want to say very much. I've said probably enough this morning. I do think there is a legitimate public safety issue here. It would seem remiss of the committee not to at least get some input from someone from the Transport Division of the Council, and that will either confirm or allay any concerns that the committee may have. In relation to the point made by Mr. Thompson about safety not being a consideration, I find it difficult to believe that a court would not have regard to safety of members of the public in coming to a decision whether or not it was reasonable to allow members of the public to use a track. I do understand and I'm not denying the words of the section, but I suspect that the context in which they're used is rather different to the danger that I'm alluding to in this case, which I believe exists and which I believe the committee should have further information about before making its mind up on this matter. Thank you.
Okay, thank you very much. So that sort of concludes that section. The next section now is that I would like to invite elected members if they have any motions. Councillor Hans.
Yeah, Convener, I would just like to move the recommendations of the report as the motions. I think that there is an issue about the wording in the legislation versus safety, but as Mr. Thompson mentioned, section 28 allows for the option of a declarator to be requested for the courts to repeal any obligations on the ground. So I think just now, as the legislation stands and the information we have, I would just like to move the recommendations of the report.
Okay, thank you. I think what I'm going to do, just so we're recording this, and it's obviously going to be broadcast, is if I read out what the report recommendations are, because some people watching this will not probably be aware of what the proposals are from in the report. So the recommendation is it's recommended that the subcommittee 1 notes the contents of this report, 2 agrees to proceed with the formal enforcement procedures, including serving a notice under section 14 of the Land Reform Scotland Act 2003, and thirdly agrees to defend any subsequent court case in the event of the notice being appealed to the Sheriff Court, and to take any additional or alternative enforcement proceedings as the Director of Legal and Democratic Services shall deem appropriate. So that is the motion that Councillor Hans is moving. Do you have a seconder for that?
I'm happy to second that, Convener.
Okay, so that's seconded. Thank you. Do we have any amendments? No. So the motion therefore is carried. So I think I can just now say that the decision of the subcommittee is the recommendations in the motion that's just been agreed by the subcommittee. Karen, is that the end of the process?
Convener, yes, that's the end of the process. The decision has been made.
Okay, well, thank you very much, everybody, for coming along today, and we'll see you later.
Thank you.
Thanks, Mr.